Dear learners, today I am going to discuss very important aspect of Muslim personal law, that is Muslim law of inheritance, that is succession part, means who will be entitled to succeed the property of a deceased Muslim, and in what manner the property of a deceased Muslim will be distributed, what are the different classes of the heirs of a deceased Muslim, and how and in what manner they will be succeeding to the property of a relative deceased. These are the various dimension or aspect of this topic that will be covered in my lecture today. Ladies and gentlemen, on the basis of discussion on the topic of administration of the estate of a deceased Muslim, there should not be left any doubt in the mind of learners that under Muslim personal law there is a well established principle for the application and disposition of the estate of a deceased Muslim. I have already explained the concept of administration of estate of a deceased Muslim. The Muslim law recognizes four main charges on the estate of a deceased Muslim, and in order of priority, those charges are may be mentioned as expenses made on that is funeral expenses are the expenses incurred on the performance of the last rites of the deceased, are known as funeral expenses. So, this is the first and foremost charge. I have explained. Next to it is debt of the deceased, means unpaid debts of the deceased. That is the next second important charge running over the legal charge running over the property of the deceased. Legacies, claim, then the last is claim of the heirs. The estate of a deceased Muslim is successively applicable for the payment of the charges just I have pointed out one by one. So, after the payment of above three charges, that is funeral expenses, debts, legacies, whatever property will be left of the deceased, the leftover property will be known as the residue property of the deceased or residue estate of the deceased, and residue property of the deceased will be the legal claim of the legal heirs of the deceased. Therefore, the residue property of the deceased will go, that is will be distributed among his legal heirs, that is among the legal heirs of the deceased person according to the rules of Muslim law of inheritance. Ladies and gentlemen, I have just stated that after the payment of the three principal charges, whatever property will be left over, that will be the known as residue, and the residue property will be distributed among the legal heirs of the deceased. However, in order to make the distribution of the property effectively and as per rules of the Muslim law, it is necessary that heirs should be recognized, should be identified, should be understood as to who are the persons who in the given situation or circumstances will be entitled to share or to inherit the property of the deceased. They will be the persons succeeding to the property of the deceased. We are called as heirs of the deceased. Heirs here means a relative or set of the relatives who are connected to the deceased either by blood or by affinity, and as per rules of the Muslim law entitled to inherit the property of the deceased. All such relatives connected to the deceased either by blood or by affinity will be called as heirs of the deceased. Therefore, on the basis of importance, the heirs of a deceased Muslim have been classified into two. One is called as primary heirs and other may be called as secondary heirs. Primary heirs means relations closest to the deceased and who on account of their proximity are always entitled to inherit, never excluded by anyone. And one can guess who may be those relatives who are may be classified as primary heirs closest to the deceased, always entitled to inherit, or they are 6 in number, and they are of spouses, that is husband or widow, as the case may be. This is one set of the persons who happens to be related in his life, in the life of the deceased, by affinity, that is by marriage. So, in the case of death of the husband, his widow will be considered as the primary heir and will always be entitled to inherit something out of the estate left by the deceased. Next to them are the children of the deceased, that is sons and daughters of the deceased. Next to them are parents, that is a father and mother of the deceased. So, these 6 relatives basically are known as primary heirs of the deceased, that is spouses. Number 2, children, that is sons and daughters. Third, parents, that is father and mother. These 6 persons who are related to the deceased either by blood or by affinity, because surviving spouse, husband, is related to the deceased by affinity, by marriage, by violent marriage. And in the event of the death of the wife, surviving spouse, husband, is related to the deceased by affinity. So they are entitled, that is, the surviving spouse is entitled in the property of the deceased wife, and surviving spouse, wife, will be entitled in the property. So there is a mutual right of the inheritance based on affinity in the property of either spouse, and they are the primary heirs, always entitled to inherit, never excluded by anyone. They are entitled to a definite share. Next to them are children, that is son or daughter or both. They are also primary heir, and being the primary heirs, they are also always entitled to inherit in the property of the deceased. They will take some share as prescribed by the Muslim law. I will discuss later on. Next are that is parent, that is father or mother or both. They are also primary heirs and always entitled to inherit out of the property of the deceased, a son or daughter, as the case may be. So these 6 relations have been identified under the under the scheme of the Islamic law of inheritance as primary heirs of the deceased. Why are they called as primary heirs? Reason: because they are supposed to be closest to the deceased, directly related to the deceased, and therefore on the basis of their importance, they have been identified as primary heirs. They have been designated as a primary heirs, and being the primary heirs, all these 6 relations of the deceased will always be entitled to inherit out of the heritage of the deceased relative. I have already told that on the basis of the importance, the heirs of a deceased Muslim are classified into 2 classes. One class is called as primary heirs, and another class is called as secondary heirs. Primary and secondary class of heirs. Who are primary? I have already explained. Now the next point is, who are the secondary heirs? All the relations except the 6 just I mentioned, that is, except spouses, parents, children, all relatives of the deceased who are connected to him by blood or by blood, they all are called as the secondary heirs or secondary class of the heirs. Therefore, all the blood relatives, means all the relatives, all the persons who happens to be connected to the deceased by blood, by legitimate blood, all such relatives or relations will be known as the secondary class of the heirs under the scheme of the Islamic law of inheritance. But the difference between the primary heirs and the secondary class of the heirs is that primary number of the primary heirs is very limited, that is limited to only 6. And in fact, they are closest to the deceased, connected to the deceased directly by blood or by affinity. Rest of the relatives, they are known as all rest of the relations connected to the deceased by blood are categorized or have been identified as secondary class of the heirs. Therefore, this is a broader class of the heirs that consist all the persons who are connected or who have been connected to the deceased by legitimate blood. So, all the person connected to the deceased except these six are grouped as secondary class of the heirs. Their entitlement is contingent, that is, sometime they may be entitled to succeed in the property of the deceased, and sometime they may be absolutely excluded and get nothing. Sometimes they may be partially entitled, and sometimes they will be entitled to nothing. Therefore, their entitlement or hereditary entitlement basically is dependent upon the presence and absence of some other heirs. But so far as the primary heirs are concerned, they are always entitled to inherit. Nobody can exclude them, no relation can disentitle them from succeeding the property of the deceased relative. This is the basic difference between the this primary heirs and secondary heirs, and therefore the number of the secondary heirs is not mentioned, as is the case of the primary heirs. This is the largest group of the heirs under the scheme of Islamic law of inheritance. Ladies and gentlemen, on the basis of order of priority to inherit, Sunni Muslim law has classified heirs of a deceased Muslim into following two classes. Remember, on the basis of the importance of the relation, heirs are classified into primary and secondary heirs. On the basis of the order of the priority to inherit, the Sunni law has classified the heirs of a deceased Muslim into two classes. One is called as principal class, and the other is known as subsidiary classes of the heirs. Principal class of the heirs. This class of the heirs are further classified into following subclasses, and they are class 1, Zawibul Farus, and they are also called as Quranic class of the heirs or Quranic heirs. Class 2, Asab. They are also known as agnatic class of the heirs or agnatic heirs. Class 3, Zawibul Arham. They are also popularly known as uterine heirs or uterine class of the heirs. So, on the basis of order of priority to inherit, heirs of a Muslim have been classified into two broader classes, one principal class and other this subsidiary class. Principal class is further bifurcated or classified into subclasses, and subclasses are three: Quranic class of the Quranic years, agnatic years, and uterine class of the years. Together, they constitute a class or category or group that is known as principal classes of the years. Ladies and gentlemen, now it is imperative to understand with clarity who are Zabibul Faruz or Quranic years or class 1 years. Why are they called as class 1 years or Quranic class of the years? I explain. According to the Muslim law, class 1 of the principal, class 1 of the years are called as Quranic years because they are specified in the Holy Quran along with their fixed share. In other words, this category of the years, that is Quranic class of the years, they have been recognized as years. They were conferred the status of the years directly by the fundamental source of Muslim law, that is by the Holy Quran itself. Since this class of the years are mentioned as years in the Holy Quran itself, therefore they have been given the name or designation as Quranic years or class 1 years or Quranic class of the years. They are also known as sharer or sharers. Reason because they are not only recognized as years in the Holy Quran, but at the same time, the Holy Quran itself has fixed in fraction the share for every year of this class, that is of Quranic class. Since the Holy Quran itself has fixed in fraction the share for every year of this class, therefore this class of the years are also called as sharers. 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 Their number is 12. Means the total number of the relations mentioned in the Holy Quran as class 1 or Quranic years or sharers is 12. They are 12 in number. Now, who are they? They are ladies and gentlemen, they are spouses of spouses. Spouses means husband, widow. So number, I told that the number of the Quranic years is 12, and they are husband, widow, that is spouses. Next to them are parents, that is father, mother, grandfather, grandmother. Together this category of the years are called as parents or ascendants of the deceased. Then a daughter, son's daughter, this class are these two, they are basically the descendant of the deceased, and they are mentioned as class 1 years or Quranic class of the years. Then sons, then a full sister, consanguine sister, uterine sister, and uterine brothers. So if you go and check the list of the Quranic years, this list consists of 12 relations of the deceased, and together they are known as Quranic class of the year or Quranic years, and they are spouses, husband or widow, parents. Parents is a group, consists father, mother, grandfather and grandmother. For the purpose of inheritance, this parent is a class, and this class consists of these 4 persons. Only these 4 parents are mentioned as class 1 years or Quranic class of the years. Then next are descendants. From the category of the descendant, only 2 are mentioned in Quranic category or class, and they are daughter or daughters, as the case may be, and the son's daughter or son's daughters, as the case may be. So only 2 are mentioned from the category of the descendants of the deceased. Only 2 relations are mentioned as Quranic year or years in the Holy Quran. Next to them are the collaterals, and from the category of the collaterals, 4 persons relations are mentioned as class 1 years, that is full sister, consanguine sister, uterine sister and uterine brothers. And in this way their number comes 12, and they all are known as class 1 years. Ladies and gentlemen, I will discuss the next in my next lecture.